opposition to these cases. The board also, is this loud enough? Okay. Is it too loud? The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire zoning code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, it's imperative that anyone addressing the board come forward to the front table and speak into the microphone over here to my right. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of a BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals. Case 2019-478 has been deferred to March 5th. 2020-034 has been deferred to April 2nd. Case 2020-048 has been deferred to March 19th. And case 2020-033 has been withdrawn. That's on the short-term rental docket, the last page of the docket. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, the case is then recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for consent, please raise your hand, maybe speak up, make sure I can see you since my back is to you, and we'll remove the case from the consent agenda and hear it in its regular order. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First case, 2019-440, involving property at 2461 Una Antioch Pike. This is a special exception request to use an existing residence for a church. This is recommended for consent with the condition that the special exception applies only to the applicant. So if the applicant were to move out or sell the property, anyone else would need to come in and get another special exception if they desire to do the same activity. Is there anyone here in opposition to case 440? In opposition to it? You're here for it? Okay. Next case, 2020-044, involving property at 6353B Columbia Avenue. This is a variance request to permit a covered deck. It's recommended for consent that with the condition that the deck not be enclosed. Is there anyone here in opposition to case 44? Seeing none, the last case recommended for consent is 2020-051, involving property at 4115 Kimbark Drive. Is there anyone here in opposition to case 51? Seeing none, to review, Mr. Chairman, the consent agenda items are case 2019-440, 2020-044, and 2020-051. Staff would solicit a vote from the board at this time.
And I think that 051 had the condition that it be.
I've spoken to the applicant about that.
Okay, yeah.
That it be limited to 2 stories as submitted by the site plan.
Right, that it has it's to keep the rhythm of the other development that they're doing.
Right.
Keep it 2 stories instead of 3. All right, we have a motion for consent agenda.
Motion to approve.
All right, have a motion, have a second. Any discussion? All in favor, say aye. Any opposed? Consent agenda passes.
Members of the public, if your case was just approved on the consent agenda, you are free to go. Please give our staff until Monday to process all the documentation associated with your appeal, at which point you can come in to pursue the permits for which you have applied. I don't see any elected officials here today. So before we move on to the cases to be heard, the board is going to break for an executive session with our legal counsel. For members of the public, this is not open to the public. It has to do with litigation. So we're going to step out, hear from our attorneys, and then we'll be back to move on with the remainder of the meeting. Board today on February 20th. First case for the board to consider is case 2018-661. This is involving property at 1102A Joseph Avenue. This case was previously heard by the board on December 13th, 2018. The decision of the board was appealed to Chancery Court, and the case has now been remanded by the court. So y'all can go ahead and take that case up now.
All right, and so this is a case, as you hear at the beginning of our meetings, if the applicant or the opposition to a case does not like the decision of this board, they can take the case to Chancery Court. In this case, it was a short-term rental permit that was in an SP zone. And based on the specifics of this case, the law that was at the time and other specifics of the case, the court ruled that in this particular case, the zoning administrator did err, and we erred in supporting the zoning administrator's decision in this case. So based on the order of the Chancery Court, I'll make a motion that the zoning administrator did err in the case and the short-term rental permit should be reinstated.
I will second.
Have a motion, have a second. Is there any discussion? All in favor, say aye. Any opposed? That motion passes 4-0 to 1.
Next case is case 2019-028, 719 Douglas Avenue. This also was heard by the board previously on January 17th, 2019. This was also appealed to Chancery Court, and this was also remanded to the board.
All right, and this is the same type of situation in an SP zone based on the law that was in effect at the time. And based on the order of the Chancery Court, I will also move that the zoning administrator erred in this case and that the short-term rental permit be reinstated. Have a motion, have a second. Any discussion? All in favor, say aye. Raise your hand. Any opposed? That motion also passes 4-0 with 1 abstention.
Next case for the board to consider is case 2020. Let's keep this rate going, by the way. Case 2019-037 involving property at 3928, 3930, and 3932 Gallatin Pike. This was previously heard by the board on February 6th. This is a request for a parking variance that failed to receive 4 affirmative votes, and so it's now before you, not for a public hearing, but just to reconsider for the purposes of making a motion to see if we can get 4 affirmative votes, strictly on the parking variance. The other issue that was applied for has been handled and dealt with. Yeah, so Ms. Karpanek, you were the board member who was not here. Did you have a chance to review the hearing from this last meeting?
Yes, I did.
And are you prepared to vote today?
Yes, I am.
All right, that being the case, y'all can go ahead and move forward with the vote on this one.
I will say I am ready to support Chairman Taylor's motion, if you'd like to make your motion again.
which
Since you just reviewed the case, I think that,
I
yeah,
can give you all a quick summary.
well, yeah, if you just, somebody,
I can,
The motion that that Mr. Taylor made last time was a motion to approve the variance for 1 year in order for them to see if that works and come back to the board if they need, if they can comply with the law at that time, then there would be no need for a variance. If they cannot, they would come back before the board. So ultimately, it was a motion for a 1 year variance.
so I'll reinstate that motion, and you second that motion?
Sure.
Is there any discussion on that motion? All in favor of the motion, say aye, raise your hand. Those opposed, that motion fails 3-2.
Do y'all want to make the opposite motion that we did last time as well?
Well, and, you know, and to some extent, the outcome is the same. I mean, it's, you either, if you believe that the law is going to change and that the property is going to be rezoned into the UDO, or whatever it is that they were wanting to do to make them have to only have 40 spaces instead of 70. If that happens, and before they wrap up, they're good to go. Otherwise, they have to go find they have to rent a parking lot to get their spaces before they can get their permit, or whatever time you have to do that. I don't know the
I also would
exact
point out
procedure, but
sorry, go ahead.
it seems like on either motion, the outcome was very, very similar. It was just a different way to get up the hill, which is ultimately comply with codes, and whether that's.
Now, Will, as I was going to point out, the board rules allow 30 days to get 4 affirmative votes. The next meeting would be March 5th, which would be, I think, 29 days. So we can leave it open for another meeting, come back. At that point, presumably, Mr. Pepper will be back, and maybe with 6 members, we'll get a vote one way or the other. And if not, it would be deemed denied by operation of law.
Right. And again, to me, the goal was the same, was to comply with the zoning code, but to do so with the expectation, based on their testimony, that their zoning may change and they may have a different requirement shortly. And it may, like I said, may or may not happen. So, all right, we'll keep this thing open as long as, I think through the next meeting.
March 5th, so you'll come back on March 5th, and they'll reconsider it and revote then.
All right, thank you. Good luck. Next case.
Next case for the board to consider is case 2020-039 involving property at 3804 Fairview Drive. I don't see Scott Morton here on this one. This is a request for a sidewalk variance. It was previously deferred. I have not heard from Mr. Morton. It may be appropriate to defer it one more meeting to give him.
It's been deferred once.
It was deferred at his request last time, at the last meeting, yes.
Sidewalk Villalobos. Mr. Chairman, I've actually worked with the appellants on this matter, and that is still under advisement. If we could respectfully recommend one more deferral, it looks like that may be handled administratively through the waiver process rather than through the BZA. And if that's the case, it'd be nice to be able to keep that off the board's docket, of course, but with a recommendation for a deferral based on that somewhat unique circumstance.
Okay.
I think that would at least keep this open in case it has to get here.
Sure, that sounds fair. I'll move that we defer this one meeting.
Which case?
Have a motion, have a second?
39.
Yeah, it's 39. It's the sidewalk variance that.
Okay.
All right, so I have a motion, have a second to defer this case one meeting. Any discussion? All in favor, say aye. Aye. That is deferred.
Next case, 2020-040, involving property at 823 and 825 21st Avenue North. I do not see the appellant here for this particular case either. This is one that the board heard at the last meeting. It was a request for a variance from setback as well, from the variance from the rear setback, from 20 feet to 10 feet. The board had previously deferred it so that the applicant could get in touch with his council person and also provide more specific information. I did speak to the appellant yesterday, who advised me that he would be here. I don't, whether you want to defer it, push it to the heel of the docket, I'm not sure. I do believe the opposition is here, so however y'all want to handle that.
This was,
Strongly contested last time.
yeah, I mean, this is a case where he had narrow lots, but what he was describing at first wasn't necessarily what he described toward the end, and I think that's what had upset the neighbors, and we felt like it was fair if you're asking for a variance to show what you're going to actually do. And so he was supposed to have come back after meeting with the council person and the neighbors to explain a little bit more.
She came back.
Yeah, the neighbors are here. We have, I guess, only a couple more cases. I'm okay with letting this sit today in case he shows up in the next little bit. Just make sure he's not down the hall or what have you. And then we can decide this at the end of the docket. If he comes in before, and out of respect for the neighbors, we'll hear it as soon as he gets here. If he doesn't, then we will make a determination at the end of the day.
Don't let me forget.
Is that okay with everybody? All right, let's move on to the next case.
Next case is 2020-047 involving property at 0 Trimble Avenue. This is a request for a lot size variance to construct 2 single-family homes. Before you is a zoning map showing the zoning of the property is R6, showing the lot indicated in red before you. This is the aerial photography giving you a sense of the surrounding area. This is the site plan that was submitted by the applicant, and then finally the current conditions of the property. Is there anyone here in opposition to case 47? Seeing none, you'll have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
I'm Ryan McClary, Rhythm Homes and Development, 2805 Lakeshore Drive. We're the owner and developer of the lot. The lot is very close to being 6,000 square feet, but it does fall just shy. So that if you look on GIS, the lot is described as being 40 by 150, which would be exactly 6,000 square feet. We've built on another lot in the same neighborhood that was the exact same dimensions. It was exactly 6,000 square feet. So what's going on with this one is the lot's not perfectly rectangular, it's a little askew. So when you do your survey, you end up a little bit short. What's kind of unique about the lot is it actually faces both Trimble Street and Hubbard behind it. So if you look at our site plan, we'd actually have, it would appear from Trimble to be a single family home facing Trimble. And our elevation example shows that we'd use most of the width of the lot to create that single family look. And then from Hubbard, we'd also create a single family appearance. So it's 2 houses on one lot, but front and back, which is very common in this neighborhood because of most of the lots being 40 feet wide or sometimes less. You know, we'd have 2 homes, but kind of that single family appearance. And if you look at our block next door to us at 46 and 52 Trimble, those are both existing duplexes on the same size lot as ours. 32 Trimble to the left of us, which is on the corner, is a triplex. You can see it's just kind of going off the map there on the slide, but there's actually 4 units being built currently, almost complete. Same setup as ours, but it's 2 projects essentially next door to each other. It's 4 units, 2 facing Hubbard, 2 facing Perkins. There's more new construction, 1 block west on Trimble, and actually a 37.5-foot wide lot. That's a little bit deeper though, so they met the square footage requirement. So I guess all that to say, you know, we feel like our lot is appropriate for 2 units, like most of the other lots that have gotten duplexes in the neighborhood. But because our lot is slightly askew, you end up with this oddity of falling short technically on square footage by the survey.
So if you were to look, I mean, if you look at just on the Metro map, it says it's 40 by 150, which is 6,000 square feet, but it also shows it as a rectangle, and the survey you have is what is that?
Parallelogram.
The parallelogram.
Thank you.
Thank you. First time we've heard that in a while. So that's your. So you're saying if it were
Yes.
true, if the angles were 90 degrees, then you would have.
Right, so you lose square footage. Yeah, it's kind of without going into like ninth
Too
grade
much more geometry.
or whatever, you know. But yeah, you lose square footage when you're not at right angles. So yeah, that's
Well, and I know that we have a note from the council, your council member supporting this, and you know, a lot of times, you know, we almost always hear the lot size variances, and I tend to look at them in terms of do you get something that your neighbors don't? And it looks like there are 4 lots that are next to, one on one side, 2 on the other, that are very similar. And then, but everything else in that block has the ability to do what you want to do or more, it appears.
Correct.
And the other 3, and it looks like across the street on Hubbard, well, I can't really tell by the measurements if those are similar shaped lots or not, but there is, at least on the corner, a duplex labeled, at least there's a B and an A. If there's a B, there's got to be an A. So
Yeah,
there's a,
that one actually, excuse me, is 4, because it's 2 facing Hubbard and then 2 facing
Okay.
Perkins.
and I guess, do you know if any of those other 4 lots, you said that there were, do you know of any other lots that we've given a variance to on, that are impacted by this small shortage, the 4 on your block, and then maybe the others that are on Hubbard?
I don't know that any in that immediate block have been given variances, but for example, on our block alone, pretty much every lot on that street would be, if they were to tear down what was already there, they'd be allowed to build another duplex. So like on the corner is a triplex, then a duplex, then us, then a duplex, then a duplex. So those are all existing duplexes, or the triplex on the corner.
Are you saying there's a duplex right next to you? Which one is that? Because you're in the red, so is it to?
I think it's actually the one to the left and then the 2 to the right. Those are all duplexes. And then the one on the corner.
Oh, they're duplexes, but they're
Existing.
duplexes that are one, they're not 2 homes like you're wanting to do, but they're a duplex that are attached.
Correct.
Okay.
Yeah.
So they would be maybe, or they'd be grandfathered, or?
They would be considered legally nonconforming. I don't know exactly when the zoning was changed, but if they were in existence, when they were in a zoning that allowed for it, and then the zoning changed to single family, it'd be legal.
Okay.
Or lot size, whatever the zoning, it would be considered legally nonconforming, whatever.
Okay. All right. Any questions from the board? Anything else you'd like to add?
No, I think that's pretty much it. Yeah, Councilman Sledge was in favor. He said he normally supports anything over 90%, and we're over 95%. So we're really close, so appreciate your consideration.
Okay, thank you. We'll close the public hearing. The one thing I didn't know when we reviewed these cases for the consent agenda was that the existing residences adjacent were duplexes.
I've never known that.
And so, to me, that the only issue I was really struggling with it, especially since it has council member support, is this, is it setting a precedent? Does he get something that his neighbors don't? And I think with the legally non-conforming duplexes already adjacent, to me, that concern goes away, and he's within that 95%. So I don't have a problem.
His zoning is R. It's not RS zoning, it's R. So, the intent of our zoning is to allow 2-family
It
homes.
is.
So
So
I don't think it's a matter of,
The lot size is the issue, not the use.
Yes, the 288.
well, and I was, and I'm sorry, I wasn't clear. I was only saying, if everybody had to come and appeal it, but it sounds like the others may not have to because they're already legally non-conforming, that we're not setting a precedent, so everybody's got to come and ask for that 200 feet. Like, they may not even have to come. Yeah, I know, everybody. So anyway, so I guess the bottom line is, based on everything I've heard, I don't have a serious issue,
I'm going to
especially
make a
with
motion, if I could, that we go ahead and grant the variance. I mean, these people,
But-
with all of the other multi-units there already, I think this is actually a better way to do it instead of having a duplex, so.
And based on the parallel agreement.
Parallel, yes. The lot size, the uniqueness of that particular lot.
Have a motion, is there a second? Have a motion, we have a second. Any discussion? All in favor, say aye. Raise your hand. Any opposed? That motion passes. Good luck. Next case.
Case 2019-049 involving property at 908 Cheatham Place. This is a request for a variance from the garage door orientation requirements to construct a single-family home. Before you is a zoning map showing the zoning is R6A, and that's where we get the garage door orientation requirements because it's in an alternative district. Before you is an aerial map showing you the property and surrounding area. This is the site plan submitted by the applicant, and finally, the current conditions of the property from photos from a recent site visit. Is there anyone here in opposition to case 49? Seeing none, you'll have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
All right, I'm James Crockett with JAC Investment, 934 Gallatin Pike. So this lot, basically, we do not have street or alley access to the side or rear of the property because it's backed up. Property's backed up to another property, and then it's two properties on both sides of the lot. So our only option for garage parking or parking off the street is that garage facing Cheatham Place. Actually, last year I actually got approved about 2 blocks away in the same area for front-facing garage on 1219 11th Avenue North.
When was that? Were you?
That was last year. I think it was in May or June. But it's on 1219 11th Avenue North.
Is there, I remember us having a lot of R6A cases, and at some point, I know we were telling everybody, don't, this is it. We're not doing, this because R6A definitely doesn't want front-loaded garages. And I know you have a unique situation, and the last R6A case that I remember us hearing, they were asking for a parking pad. And can you tell us why you need why a garage instead of, a variance on being able to just allowed to park in the front? And because, the only thing I'm trying to struggle with is most of the time R6As didn't start out that way. They were changed to R6A so that you wouldn't have the neighborhoods with the front-loaded garages. And so I'm just trying to think, yeah, I see your lot is clearly landlocked.
That's correct, yeah.
And given that I can see that there is a hardship, what is the best solution in R6A? And are there other alternatives besides a front-loaded garage?
So you would allow parking pads?
Well, I'm asking the question because it's.
The only other option I see is either a parking pad or the owner's parking on the street.
And I don't know what that.
Because we can't get there any other way. We can't get to the back. We can't get to the side. So I look at it like either they're going to be parking on the street or parking on the front.
Yeah.
I don't see any other option.
Do you have a you prefer a garage?
Yes, that's correct.
That's right, because you can't even ask for a garage, so I get.
That's correct, yeah.
And I think our architect is looking up some information, but.
Looking up what it says in the zoning code about the parking pad and.
Have I missed, excuse me, have I missed it, or has the council member weighed in on this? It would be O'Connell's district. Have you weighed in with Freddie O'Connell, who's your council member?
I haven't.
Thank you.
Yeah, I didn't, because I guess I didn't weigh in on my 11th Avenue property and got approved.
Yeah.
I didn't know anything about, y'all.
Well, and there were a lot of folks that were coming and bringing some hardships, and I think the board, and some of them were very unique, and like, some were, much less obvious than maybe this one as being a landlocked lot, but I think at the time the board, it felt like, well, we don't want this to be a habit because R6A does mean something,
Yeah.
but it needs to be a pretty special case, and so you're making a case that this is, and I get that, but that's why I was asking.
Yeah.
Are there questions, or I know everybody's kind of, I know we've all taken a look at it before we came, but everybody's given what you're telling us, everybody's kind of taking a look
Yeah, I understand.
and thinking, so we'll give them a chance to do that.
So the lot is 37 feet wide,
37 feet wide, that's correct.
and the home is proposed to be about 30 feet wide, is that right?
That's correct, yeah. Yeah, it was actually approved, like the setbacks were approved in a previous zoning before I purchased the property. They just didn't include the garage, even though they sold me those plans also with the garage.
So we've already given a lot size variance.
A setback variance, let me double check. This came before you back in December of 2019, and you granted a lot size and variance, yes. I'm sorry, lot size and setback variance.
We did not, so there's still a chance to ask questions. And what, I'm sorry, what hearing was that?
That was in December of 2019.
December 19. Are there any other
I would
questions?
like him to clarify what I thought you said was that you just bought this not too long ago,
That's correct.
and the former owner told you that the setback variance included a variance for a garage?
No, I didn't say that.
Oh, okay.
No, he actually, he told me that his plans were approved, but when I went to go pull the permit in January, the garage was not included in that appeal that he went to in December.
Thank you.
Well, and I don't know, we don't have the record from that last case either, do we?
I'm sorry, I was just looking for it. I don't have that, I apologize. So I don't
No, I
have
was
that
trying
order.
to look for it too. You said it was December,
2019.
which December?
The case was number 492. I'm not sure. Oh, you know, I think did we only have one meeting in December? Or did we have two?
It was December 5th.
December 5th, he said.
It was December 5th.
Seen him on, I just don't remember. I wish you'd talked to Councilman.
Well, yeah, there was a December 19th and a December 5th meeting. We don't know which one it was, so do we?
5th.
5th? Oh, thank you. Probably have already said that twice. And
You know, Mr. Chairman, I kind of wish he had talked to his council just to get some input. It sure would help me a little bit.
yeah, I agree.
The
And
chair wanted to maybe suggest that, because right now I'm not predisposed to.
I agree. Emily, do you know what was the case number again?
2019, 492.
492? All right. I have the packet, and I was going to see if there was a site plan at all presented.
So I was told that the councilman approved his plans, but I didn't talk to the councilman.
Yeah, the only thing that, I think what was presented before does look like it has a garage, but we wouldn't, that wasn't on the docket. It does have a concrete drive, but it's not an obvious garage, and that wasn't something that was under consideration by this board at the time, or you wouldn't be here. But it does look like it's, like you said, you bought the plans too, so the plan's here. So there was a comment from one of our members about hearing from the council person. Is that something that would be helpful, or what are you thinking now?
I don't know if it would be helpful. I think this one is a little hard because R6A is supposed to mean something. And I think if you keep making exceptions to it, then it doesn't really mean, it's not doing what it intended to do. And so I'm more inclined to preserve the R6A zoning and just not allow a garage because we've already allowed two other exceptions. However, I am sympathetic to the applicant because he did present those plans. We just didn't have that in front of us. So like from his perspective, he probably thought, you guys have seen these plans, you approved it, so I understand the predicament that he's in. So I think maybe hearing from the council person might help. I changed my mind as I was talking. I talked myself into it. But I will say, though, like, I don't like, as a general rule, not to do things that are an exception to R6A, because R6A is an alternative design, and it has certain codes, and that's why it's I don't know, so I like preserving that.
So given a 30,
Well,
I'm
I
sorry.
would like us to close the public hearing and have some more discussion.
Okay.
Is it closed or?
Sir, do you have anything else to add at this point?
No.
Okay, then we will close the public hearing and have a discussion.
Well, I'm concerned about the buyer having to park on the street. If you've visited a friend in East Nashville and know that nobody over there has parking except on the street and how horrible that is, then we need to think about that. But I agree with my colleague that to hear from Freddie O'Connell would really help me, because he knows that district much better than any of us. And he would have a feeling for whether it was worth it for us to grant this variance.
And
I'd like to
he may
I'd
decide to
like to
weigh in or not, but at least we would know, and if he chooses one way or the other. But I guess the only question that I have is, if you have, we were given a plan, and the board did say, yeah, this is an acceptable plan, and again, I spent some time looking it up because I didn't remember it, and when I saw it, even when I see the site plan that's presented to us today, and I think all we have is a site plan, we don't have the, I don't think that in our packet we have the elevation drawing, and so, it shows a pad, concrete pad. It's hard. It's one of those garages. It's a little bit hard to see that it's a garage unless you look pretty closely. So I don't think, and again, it wasn't on the agenda. It wasn't a topic of discussion. But to me, the lingering question is if those other hardships are met, to have a house there in an R6A district in a place that you can't access the back or the side, what do you do? Would you allow a parking pad and no garage to preserve R6A? I don't think you're allowed to even build a one without parking though, right? Don't you have to have parking to get? So there has to be parking for this to be a buildable lot, so. Either on street or on site. So on street could count if it.
I think you
didn't hear
can build on the
Connor. What
lot.
did you say about on street?
They could partially satisfy the rule.
And our architect is telling us
Still
that.
didn't hear you.
The on-street parking could potentially partially satisfy the
Okay.
parking
Thank you
requirement
very
for a buildable lot.
I think you can build on the lot with a drive that brings you to the back of the property. Just the way I calculated it. I think it would still be a buildable lot if the variance wasn't granted.
It might have to have a new plan, but it's a buildable lot.
Yeah.
Which goes back to your.
Yeah, you can build on it. It would be a skinnier home, and the neighborhood may prefer a home with a front-loading garage versus a skinnier home. And I think it'd be interesting to hear what the councilman has to say about that, because he's familiar with this neighborhood.
So is that someone?
Can I make a motion, we defer this?
And I'll second at
So
least one meeting.
One meeting?
Yeah, I think it might be in everybody's best interest.
Okay.
So you heard the struggle that we're thinking with, the preservation of R6A, the fact that it, with a new design, is most likely buildable. But if the council member comes back and says, well, no, in this specific case, it's probably better to have a different type of home, then that would bear weight too. And again, it would bear weight. I can't say that everybody is, but at least it would give us full information and a neighborhood representation of what you're trying to do in that R6A.
Okay.
It would, one meeting give you time, that's the 5th of, I think it's probably is, it's February short, it probably is about 2 weeks.
5th of March.
The 5th of March? Okay, the motion is to defer to the 5th of March, I think, as a second. Any other discussion? All in favor, say aye. All right, we will see you back on the 5th of March. Good luck. Next case.
Next case, 2020-050, involving property at 91 Claiborne Street. This is a request for variances from the minimum lot size requirement, driveway access requirement, and garage door orientation requirement in the R6A district to construct a single-family residence. Before you is a zoning map showing the zoning of the property is R6A. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant. And finally, the current conditions of the property. Is there anyone here in opposition to case 50? Seeing none, you'll have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
Josh Helmer, 1071 2nd Avenue South. All right, so there are definitely a few variances that we're asking for. The first one being the most important. So I believe the property came back at 5821 square feet. And I'm asking for a lot size variance to put 2 homes on the property. We did the same thing right behind this property, actually at 72 Maury, with permission from the board. It actually sparked a lot of good things in the neighborhood, in a neighborhood that is not seeing a lot of development. And so we are hoping to do the same thing here. If granted the variance to build 2, then the garage door placement comes into effect, because then we would need a place to park for the front house as well. So I think the big question is if we can build 2 homes here, and if we can, then the discussion about the garage door comes into play.
And then what is the actual size of the variance and the lot size?
It came back at 5821, so it's 189 square feet short. I'm sorry, 179.
And then do we have the neighborhood view, the Metro map view?
Right map.
Well, I think we may have heard the other one that.
Yeah, I don't think that's the right map.
That one.
You see, they are just behind the red arrow on Maury Street. I guess this is an older picture. You can see where we're under construction with the 2.
Yeah, we have a picture in our packet on our computers that shows the one behind that you've already done.
I did shoot emails to Councilman O'Connell. I know he is very busy, so we went and walked around the neighborhood and talked to the neighbors about doing the same thing on Claiborne that we did on Maury. And the only thing that we heard was maybe less modern. They might like to see gable roofs, and I'm totally fine with that. But we had a lot of neighbors in favor of it.
I guess and I don't remember the case of the ones that you've already built. But again, going kind of back to the conversation that you just heard with the R6A, and I guess the question is it possible to design, 2 homes without kind of that front-loaded garage? Because the houses, at least in the picture that you submitted that shows the building behind it, it does seem like, the houses on Claiborne are all, none have a driveway in the front. It's all sidewalks up to existing homes, and there probably is a disruption from that curb cut, and we may have just missed it on the previous.
I think when we did 72 Maury, the neighborhood wasn't R6A yet. It was just R6, so it didn't come into play. Down
So
the
it was
street,
just a lot size variance that that makes more sense.
correct. Yep. And down the street on Claiborne, past Fane, there are pull-in driveways. There are definitely pull-in driveways on Claiborne. I think my understanding of the R6A neighborhoods or the district when talking with the council members is it's more about the walkability. I haven't really heard anything negative about the garages per se. But I think it's more about the placement of the homes for walkability.
And why would you go to A? I guess why would
We
there
didn't go to A.
be why would there be a prohibition of front-loaded garages and front-loaded carports if
I'm
that
not
didn't mean
sure.
something? You know what I'm saying?
Yeah, absolutely. No, it's definitely part of the alternative district. But I think it seems like the main objective there is walkability. And maybe cars backing out of front-loaded garages affect that. This lot is only 35 feet wide. It'd be very difficult to have a driveway go past the other house. We could probably find room to put a pad in the rear for that front house, but this is not the safest neighborhood right now. So I don't know if I would feel comfortable doing that.
Only thing I wanted to say is that this is also a little different than the last one in that there is like an alley access off the back. It's not landlocked like the other one. The other one, I at least saw more of a hardship because it was kind of a landlocked property. This one, I mean, I've said this before and I'm just going to keep saying it, like certain horses aren't made for certain courses. This is a very narrow lot. At least there's alley access. And I think the legislative change to an R6A district signifies something. And so without more, I don't think I can support the variance.
I agree with you, and also the prior one was a single-family home.
Yeah, I don't have as much of an issue with the lot size. I mean, the council member hasn't weighed in, but with it being, reasonably close, I haven't compared it to the others. At some point in time, with another plan, might be open to that. But it also does seem to be an opportunity to come up with a design solution that, what do you do in an R6A on a skinny lot that you really want to build two houses on and you have alley access? So what is the creative solution there than the model that is very, very common? I mean, it's common because it works on most lots, but it doesn't work on this lot because it's too small and it's an R6A.
That's definitely something that I'm interested in as well, because I have property over here that is like 38 feet wide, and it meets the 6,000 square feet requirements, but again, there's no way to get parking to a front house.
Right. Well, and
Once they changed to R6A, it became difficult to actually, do the two homes.
Can the drive be on the side setback? Okay. I think you can do it. I'm looking at it.
Well, and I mean, there are a lot of choices. You want two detached single-family homes. You want independent access points, and I totally understand from a market perspective why. But those are all choices, and maybe this is, like I said, to me, it just screams, creative solution. And once you get one, then you've got the model, and you may be the first to solve it and do something new and different and really exciting in that R6A. But I tend to agree with the comments that there needs to be a different approach to it. But
It's not the same as the other. Are we
did you have anything else to add at this point? I mean, you've heard kind of where we're headed on it, but if you have something to add, then please do. Otherwise, we'll close the public hearing.
No, I think that's it. No, I think that's all. Thank you.
Okay. We'll close the public hearing. No, but I mean, like I said, I think to me, I mean, we have our architect.
I want to hear what Christina has to say about it.
I know, but over here cheating on you.
Well, it's a 35-foot wide lot. If you can build the driveway on the side setback, and let's say you build a 12-foot wide driveway, which is the maximum you can build according to the code here for this particular zoning district. And then you include the 3-foot side setback on the other side, you'd be down to a 20-foot wide home, which is buildable. There's 20 feet, and I've said this before, I live in a 19-foot wide home, so I can tell you it's doable. So I do think it's possible to get a drive from the alley back to the home that's closer to, is it Claiborne? So I don't see the hardship there to allow the variance for the front loaded garage. But for the lot size, I think we should take those up as two different motions.
Two separate. And I guess I'm, I would be much more inclined to give a variance for a shared 4-car garage coming off the alley. Side variances or even rear variances of some sort, just if you needed a enclosed garage. But again, to me, the choices that are there, I certainly understand, but they're dictating the request, not the lot. But I do think that if you feel like there's a hardship for the lot size variance, I'd be willing to consider that one. But not the other two at this point.
Well, then I'll make a motion to not to deny the variance request for the driveway access in the front loaded garage.
But grant the minimum lot size variance.
We can add that in there, sure.
Well, I mean, but is it,
Two separate, but
oh,
we
two
can
separate,
try.
okay. Well, no, should deny the, the motion was to deny those two. I'm sorry. So is there a second to deny those two motions, or those two variances? Have a motion, have a second. Any discussion? All in favor, raise your hand, say aye. Okay, that motion passes. And then did you want to address the lot size?
It looks slightly like a parallelogram, so it.
Well, although it's not, it's 35 by 35 by 165 by 165. It's pretty rectangular.
In the drawing, it looks slightly, but
You're trying really hard.
Well, to me, I mean, and I don't, yeah.
it's even less of an ask than the last one. That's the reason why
Yeah.
I think we can approve it. I think it could be a surveyor error. So I would move to approve the lot size variance request.
I'll second. It's within 96%.
Yeah.
So it's fairly close.
So I have a lot size variance motion, and there's a second. Is there any discussion on that? All in favor of the lot size variance, raise your hand. That passes.
Thank you.
Sure, thank you. All right, next case. Last case.
What?
It's a 5-year-old birthday miracle.
Yes, it is.
Case 2020-052 involving property at 1009 Dickerson Pike. This is a request for a special exception from, to deviate from the height requirements in order to construct a mixed-use building.
So that last case is next to the last case because we do have to address the one that the ladies have been waiting on.
Right, still a 5-year-old birthday
Just
miracle.
want to make sure I acknowledge y'all. Yeah.
So before you is a zoning map showing the zoning of the property is CL. This is the area photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant, and finally, the current conditions of the property. Councilman Parker, are you here in support or opposition? Opposition, okay. So there will be opposition here. Mr. Cuthbertson, you'll have 10 minutes to make your presentation and reserve some time for rebuttal. Of course, Councilman Parker, you won't have any time limit. You can address the board as you see fit after Mr. Cuthbertson makes his presentation.
Chairman, members of the board, Dwayne Cuthbertson, 1806 Allison Place. I'm here on behalf of the owners of the property requesting the special exception to increase the building height for the CL zone property. The request would allow a mixed-use building in a more urban form along Dickerson Pike. Specifically, it would allow the plan in front of you, which proposes a 4-story building rising to 52 feet in height at the street setback. It's important to note that we're not asking for a variance in this case. We're asking for a special exception. The zoning code sets the building height limit in certain zoning districts, and then in some cases it says buildings in excess of that height may be appropriate given the context, and then they create this pathway, the special exception for the Board of Zoning Appeals to determine, again, depending on the context, whether a building that exceeds that standard is appropriate or not. But again, I wanted to point out that we're not asking for a variance, so a hardship is not a part of my presentation, or I don't think it should be part of the board's consideration. The board does have rules specific to special exceptions, one of those being that we hold a community meeting. We did send out notices to property owners within 1,000 feet, and we held the community meeting on February 3rd. It was lightly attended. We had some that had some concerns. We had some folks that supported what we were asking once The nature of our request was made pretty clear. I did have some conversations with property owners immediately behind us that share the alley behind us. And again, once I explained to them what we were attempting to do, they were in support of it. So the CL zoning and the CS zoning has a pretty odd building height standard. At the street setback, a building can rise up to 30 feet in height. And from that point, there's a height plane ratio. For every foot of setback, the building can rise 1.5 feet. So it creates somewhat of a triangular effect from that street setback. I've provided an analysis, and there is an exhibit in there that attempts to show you what that building height looks like in relation to the building that we're proposing. Effectively, there's about a 22-foot portion of the building at the street setback that isn't specifically allowed by the building height requirement, in which we're asking for this special exception to allow. It's a very small portion of the building that we're asking for the special exception for. Our building is 4 stories at 52 feet, and if push came to shove, we could push this building back into the site and actually get to 4 stories and 52 feet. The attempt we're making with this special exception is to bring the building up to the street. We'll have to build a wide sidewalk along the entire frontage of Dickerson, and we're attempting to create a more urban form along Dickerson Pike with this exception. If we push the building back, it pushes the building back closer to the residential behind us and just makes for an odd pattern along Dickerson. So that's one of the main intents behind our special exception. The request is consistent with a lot of planning documentation out there. In fact, Dickerson Pike Corridor South is still ongoing, but has been the subject of a pretty intensive planning study. And in that planning, and it's very community involved, that planning study suggested in the future the city would like to see taller buildings along Dickerson Pike pulled up closer to the street. In fact, that corridor study provides a building height schedule for this portion of Dickerson Pike, and on this site it says a 4-story building is appropriate here. And so again, that's exactly what we're asking for with this special exception. It's also important to note that the special exception we're asking for has nothing to do with parking, has nothing to do with the mix of uses. What we're proposing with parking and the uses is allowed by the underlying zoning. The only thing we're asking for is that small triangular piece of building height. So it's consistent with planning department's recent studies. The planning department does have to provide a recommendation, and they are supportive of our request with the condition that we keep it to the height that we're requesting, which of course, that's our intent. It's also important to note that this site is within an MDHA redevelopment district, and so whatever this board approves or whatever we march forward with will have to be reviewed and approved by MDHA before.
So has this design already been approved, or have you had any?
It hasn't. We weren't, excuse me, we weren't sure which came first. And so in talking with Parker Brown at MDHA, they wanted us to come to the BZA first. And if we got approved, then we'd have to bring it to them. And that's why in my, excuse me, in my analysis, I also am asking if the board, if you are so inclined to approve our request, my hope is that you would give us a little wiggle room. So if MDHA does require some nuances somewhere in the design, that we have the flexibility to make those changes as they direct.
I would think if we approved you to be able to go up exactly like you want, you'd have all the wiggle room you want, because we'd say you could move 4 feet or 4 stories at the face of Dickerson Pike, and that seems to be the most we could do. I mean, my preference would be, I totally understand the red triangle that you have a drawing. It's on page 161 of our packet that has a dotted line showing that little section of the building that you're really talking about. And I get that it allows you to, add 10 more units or 9 more units, or however many units
Well,
are across.
can I comment on that? It doesn't allow us to get any more units. We can build the 4-story building in this zoning district.
Right.
We just have to push it back off the street.
Right. But I guess that, and you couldn't go up a 5th story.
The CL district's requirements come from the street
Right.
and the alley. So I didn't do the math because
Yeah.
we're
Well,
not
and you
thinking.
carry your line on up and see. Well, and I guess that's the thing is that it's a perfectly normal, ordinary-looking building that may be a great thing to have on Dickerson Road or anywhere, but like I said, the last one and again, it was a variance, not a special exception, but the issue was the same, and that was the step back. Do you allow a building to not have that step back? And it was a much more interesting, it's like they were requesting that in part because they had a deck with a canopy, and it was really inviting. It was on Gallatin Road down, and actually it was a part of Gallatin Road that they were trying to redevelop, which I think is going to make a nice addition. And so, and again, this is, like I said, it's a perfectly normal building, but it's not anything that we hadn't seen before. And it'd just be nice if it were a little more interesting, but that's not why we're here. But
I would consider it a building block. Every great city needs normal
Yeah.
buildings to kind of fill in the spaces and activate the streets. And this isn't at a prominent point in the city. It's not on a hill like the state capitol where you really want your iconic buildings.
doesn't have a view to.
It doesn't,
that would
yeah,
have
there's
a-
no street terminating to where this creates a really great vista opportunities. It's a lot that, it's like a missing tooth right now.
And so basically, the special exception is because of the planning, pedestrian-friendly planning, you really want to push it up to the street and to take advantage of the code that allows you to build it 4 stories. You'd like us to give you a special exception for that triangle.
The special exception, yes.
And so we're weighing that, that 4th floor impact on the street versus the building being pushed back even further.
Correct.
Okay. Are there any other questions at this point?
If you had to move the building back, how does that affect your parking area behind it?
Well, that's something we'd have to figure out. We'd have to cantilever over it. We'd have to figure out how to support the building in that parking lot. In talking with the engineers and the architects, they say it's doable. It's not desirable, but it's doable.
More expensive.
Oh, I'm sure. And I say that quickly.
That wasn't,
I
I mean, that was
don't
not
know
a
that,
criticism.
honestly.
Believe
But
me.
if you cantilever also, you lose square footage on your ground floor too.
We do lose some, we probably would lose some footage in the commercial spaces, but also the building would then be a little bit closer to the residential. And that was something that was emphasized in that Dickerson South corridor study, is that we want to be mindful of the impact of tall buildings on Dickerson, of nearby neighborhoods. And this allows us to get as far away from those homes as possible. And again, I had conversations with at least 4 people who own homes right back there. And again, once they understood the nature of what we were doing, they were supportive.
It actually pushes you further away from
the residents, from the homes.
And then I guess this is the type of project that would require a landscape buffer between you and the residences, or no? I don't.
Because there's an alley, no.
Oh, because.
But we will have to landscape that parking area for sure. So there will be trees in there.
But yeah, being code compliant. Are there other questions at this point for the applicant?
Yeah, so other than the height, our intent is that we're meeting every other section of the zoning code with this building.
Any other questions at this point? All right, we will hear from opposition, and you will have a few minutes to rebut when you come back. However many Jessica says you have.
Hey, good afternoon, Board. Thank you for being here today. So this case, I'm actually really thankful that we've had a few meetings around this case because it's given me an opportunity to really kind of dive in on how the recent Dickerson Corridor Study policy amendments interact with MDHA's sort of relatively stringent guidelines on building placement and pushing us toward a more urban designscape. My anxiety about this exemption request is that the design standards are pushing all of our traffic into the alleys. So the ingress and egress for this property is it's an improved alleyway, but it is relatively narrow. So given the wide range of uses allowed under CL, I'm concerned certain cumulative uses could yield a lot of traffic flow through the property through this single lane alley. And in addition to that, if you see where Whites Creek intersects with Dickerson is one of the most accident-prone intersections in my district. We actually had a fatality there last summer. And what I'm concerned about is with the ingress and egress being through, say, Evanston, down the alley, that might not be very apparent to, say, rideshare drivers. I'm concerned that essentially we're going to be seeing rideshare drivers parking along Dickerson, loading passengers. And I had sort of suggested that maybe we could cut into the parcel a little bit with like a loading and unloading zone. And that actually might push the building back far enough that they wouldn't need a variance for the 4 stories. I'm not really sure. But adding this, through exemption, adding this intensity with the plan as it is, how it handles ingress and egress, and how we're likely to see, rideshare traffic right there on Dickerson where there is no means to accompany it, and as well with traffic coming off of Whites Creek going northbound, that's already a very blind, left turn. And if we've got these rideshare vehicles parking there along this development, you're going to have quick lane shifts from northbound traffic. It seems like it's going to introduce a lot of conflict points.
Is there parking? Is there parking, street parking on that street now?
There is not.
It's just it's 4 lanes, two each way, or is it?
Section it is 4, yes, I believe, no turning lane.
Well, I mean, if you've lived here any more than a couple hours, people are just going to stop wherever they're going to stop. So,
that's my concern with the ingress and egress being sort of several turns away and not immediately apparent from the street. Is that we're going to have a very high volume of that kind of.
So I guess again, I'm not in the district and respect your expertise on the district. I do understand that it makes sense to further improve the alley and to not have a main entrance on that property. The alley makes sense, and especially in its proximity to the dangerous intersection. But the rideshare comment of, well, is there some kind of loading, some kind of throughway that makes it safer for people just to come and go and drop people off or a package off or something, makes a lot of sense too. And I guess the question is, what interaction have you had with the developer, and where have those conversations gone, and are the suggestions that you are making to us something that you feel is possible based on your history with the applicant?
Well, and I'd like him also to address the planning recommendations. Have you seen this? Councilmember Parker, have you seen what we've been presented with the planning recommendation on this?
I have looked at the board packet, yes.
Well, the planning recommendations came late. They came, I don't know, I just downloaded the board packet again last night. I don't think they were included.
Oh,
and the planning department had recommended approval of.
Right, and it just says buildings should be limited to a maximum of 4 stories within the proposed height of 50 feet 2 inches. and they approved the increase in height, excuse me, from 30 to 50 feet, 2 inches.
But I don't think they
With that as a condition.
Yeah, but they didn't specifically address the driveway
No,
issue
no.
that he was talking about.
So I guess that my concern is allowing the exemption to raise the setback, the front setback from 30 to 50 foot, allowing them to keep the building that close to the street does not really provide room, given the sidewalks that are going to be required, for any kind of loading or unloading. And I mean, there's I know a traffic study will be required in every case and all this and that, but I don't think that those kinds of analyses have caught up with the reality of today, where lots and lots of traffic is on these rideshare platforms. And our drivers are coming from out of county. They're not familiar with this site. They don't know how to get around to Evanston and into an alleyway to unload a passenger.
Yeah, and I guess, I mean, there's not, the only special exceptions for the height, and so he's not asking us to allow him to build closer to the street. I mean, it may be required, to get that height, he may say, well, I'd prefer to be at the street, but I think he can build at the street now, and he can build 3 stories at the street now, and he's wanting to build 4 stories at the street rather than 3 stories at the street and 4 stories in the back. I think that's, I mean, and I'm not saying this to, I'm saying this to help myself understand, make sure, I'm looking for everybody to nod and say, yeah, that's what we're talking about. But I'm pretty, certain that that's what.
I think that is the case, and then it becomes a question of, like, are we over egging the omelet here by allowing these additional units under this given configuration? I'm well aware that they could move it into the property and still build the same number of units, but that would also allow for that more flexible space up front to accommodate rideshare deliveries, et cetera.
And as someone that actually lives probably a mile from this, and I take Dickerson Road every day home, the councilman, and I was actually on the steering committee for this planning study. So I think the applicant is right. This is sort of the development that they are planning for Dickerson Road, and I think that what they presented is really nice. I think to the council member's point, Evanston that alley is a residential alley. It is not necessarily wide enough to accommodate people coming in and out, deliveries like UPS trucks. And Dickerson, despite being a 2-lane highway, he's right. If you're coming home in the evening, there's about 5 to 10 cars that are backing up trying to turn left onto Whites Creek. So then the only real lane of travel is that other lane. And so if it's blocked off because there's rideshare and everything else, I think it would be nice if there was some sort of compromise where the applicant can sort of get what they're trying to get to. We're having it closer to the street, but also maybe something to accommodate a few people coming in and out so that's not blocking up. Because unlike other corridors like Weston and everything else, there's no real sidewalks right now. It's not necessarily, there's just a lot to be done, I guess, to sort of accommodate the applicant's vision, which I think is a great vision. I just think that given the context that there is a single-family neighborhood right behind it, that right now the planning studies say will stay that way. So I just think that the council member has brought up a good point, and I wish there was something in the middle between what the applicant sees and what to also sort of address what the council member wants.
Well, and
By you saying all that, what's your position?
I'm still listening.
well, and is your ideal outcome would be to solve the issue that you're talking about, which seems to me, we can talk to the applicant again, would take some amount of time in terms of additional conversation.
And we had, you asked what my interactions had been with the developer. I had met with the developer several times. He came to a community meeting at Cleveland Park. Actually wasn't notified of the special meeting for this exemption request. A resident who lives on that block told me about it, and so I was able to attend that. And initially they had sought to rezone this property to MUNA, and I was initially supportive of that, but that process kind of halted because the owner did not want to address any of the sort of concerns around parking and traffic and whatnot that the neighbors had. So I think that's why this ended up being a request for an exemption rather than a rezoning.
Would an ideal solution be a curb cut and drive off of Dickerson where someone can pull off and stop their rideshare car?
I think yes, not cutting through the sidewalk, or not necessarily allowing, because I really do love the continuity of sidewalk that is a priority for planning and for MDHA and for myself. But something like the 505 building, where they have the sort of loading area there. I
So
think
the sidewalk goes behind the loading area?
Yes. So you have the continuity of sidewalks through there, but there is some space for all that, ride share, delivery. If we have restaurants here, we'll have the Grubhub drivers and all that. And, I just think that just given the traffic patterns that this development is likely to generate, I think that's going to be really crucial for it to
So
work.
it sounds like that your specific request today is to allow more time for that to develop.
I think that allowing this variance would I don't think that at that point there would be any more sort of community input with regards to
Okay.
how this development unfolds, and that's why I'm asking you to oppose it.
Okay. I see you said to defer this, right? So that's why you're asking us to.
I would just oppose it.
Well, I think I guess by our rules, if we oppose it, they can't apply for 6 more months with the same plan. And if we defer it, then you all can work together and come back to us in a month after you presumably all agree to a site plan that incorporates the things that you're talking about. So that's why, us denying it outright basically means that they can push it back, go up, do whatever they can in code, with or without your input. And so to me, what I'm hearing is if you feel like that you want to have more input and how it addresses that safety concern that you're talking about, then to me, the path would be for us to defer that whatever length of time it would take for you all to have that interaction. And then you may like the result. You may come back and say, it's not good for me. I still oppose it for whatever reasons you oppose it, or I support it for whatever reasons. But it seems like that would be to me, that would be the best way forward. And if you feel at some point that this is a good project for your district.
That sounds great, yes.
Okay.
If the board would like to, that sounds great.
Well, so now we need to hear from let's hear from the applicant again. Did you have anything else to add, Councilman?
No, thank you all.
All right, well, thank you for coming out today. We appreciate it. All right, we'll hear from the applicant and then figure out what to do.
So a lot of the council members' concerns are shared by the owner. In fact, at one point, we did have a plan that showed some parallel parking pull-off spaces on Dickerson, and that plan got killed so fast by Public Works. We didn't even have a chance to respond, because that was exactly one of our thoughts was, okay, if we're going to put a mixed-use building up here, there are going to be Ubers that just stop, because those things stop wherever the heck it's convenient for them. And, until we get some sort of enforcement organized against that ride share, that's the way it's going to be, unfortunately. But yeah, we did think about ways to design the sites to mitigate some of that. And yeah, we had that similar to 505. We had a little pull in off of Dickerson, and because it's a TDOT road, it's a state highway, they said, don't even think about it. And to a degree, that's their same stance when it comes to curb cuts. They want to eliminate every curb cut they can on Dickerson to reduce the number of conflicts or potential conflicts along the corridor. So I appreciate that it is a narrow alley, and we will have to widen our portion of it. It gets it to 17 and a half. Can you get two-way traffic in 17 and a half? Slowly, yes. Is it practical? Is it easy? No, but you can get two-way traffic back there. We're certainly willing to work with the council member and the community on doing something to alter the way it's designed, or the street is designed on Dickerson. If he'll help us get over Public Works and TDOT, I think we're certainly open to some sort of pull-off right there on Dickerson.
Mr. Chairman, with all due respect to the applicant, this just doesn't feel ready for us yet to act on. And I mean, I hate being I've been too nice today, actually, so.
Well, I'm going to be not nice. Because as a design professional, we go through this all the time.
Yeah.
And I believe that he's exhausted some opportunity, or presented some opportunities to Public Works that were not accepted. So I'm going to be right back at you.
Okay.
Well, I guess the question is, it's rare that we have ever heard a case where a council member had said, hey, I really would like to give it another swing, where we didn't allow that to happen, and that is what I heard today. And so I guess, do you have objection to us putting, kicking this down the road a little bit, for you all to meet, talk it through, make sure that everybody's up to speed on all the efforts that have been done, and I have no doubt that you've exhausted the efforts, and you've gone through the proper channels, and like I said, planning has recommended it. You've done everything that the rules require you to do, and in terms of getting input and that type of thing. But I do agree that it probably needs another swing at it, because the result is what you just said you wanted to. And so if there's another way to get that, then I think everybody would benefit.
Sure.
So I guess the question now is, 1 meeting, 2 meetings, what's the?
I think just for expediency, can we defer at 1 meeting, and if we can if we can work something out in that time span, then we're.
And that if you feel like you need to defer it again, then that's certainly acceptable, and you can do that administratively.
Sure.
Then I'll make a motion that we defer this 1 meeting with the ability to defer administratively if you needed to. Is that in its second? All in favor, say aye. Any opposed? All right, that motion passes. All right, good luck, and thank you all for coming. The last case that we have.
That's 2020-040. I have not seen the applicant or heard from the applicant.
Well, and
except yesterday when he told me he would be here.
Well, the question is that, do you want to act on this case, or do you want to defer it?
I personally want to act on this case and move to deny it. I think it's.
I want to second that.
All right, there's a motion to deny the variance, and there's, well,
That the people, the affected neighbors are here again. They were here last time. It was a long meeting last time.
Right.
And I'm.
and we put them through waiting the whole meeting this time
Having
too.
listened to all of this stuff.
Well, so there's a motion, there's a second, and with that, because the applicant's not here and would speak first, there's no reason to open it up for anybody to speak, right? Is that? Okay. So we have a motion.
Do what the board sees fit to do, but.
No, okay, that's fine. So there's a motion, there's a second. Is there any discussion? All those in favor of the motion say aye. Any opposed to the motion?
I wasn't here last time, so I'm going to just abstain.
Okay. So that motion passes 4-0 to 1 abstention. And I think we're adjourned.
Right.
Birthday. Birthday.
All right.
Actually did a lot more than my colleagues would do this meeting, so I was going to. Oh.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.tv.